Hello again, attorney Andrew Bethel here with another video where we talk about how to not get sued. Actually, we'll be on the flip side this time. This is actually before you go about suing anybody else, and really before you even hire an attorney. Do this first in order to save a little bit of money. For some context, what we're talking about today is, let's say that you're the beneficiary of either a trust administration or a probate, and you want to know what's going on, but you're not getting told any information. What do you do? Well, for most folks, their first instinct, outside of just kind of initially maybe asking, is to turn around, go get an attorney, give that attorney a bunch of money, and that attorney will write a letter for you. Sounds a little anticlimactic, but that's often just the opening stages of just about anything. The attorney writes a letter and says, hey, you need to give me A, B, and C on behalf of my client, and if you don't do so after a certain time period, then I am empowered to file a lawsuit against you. And oftentimes that will only just start a back and forth of sharing information, finding out where the holes are, and actually what assets might be there, again, in the context of either a trust administration or probate. However, all this can take a long time and frankly just cost you a few $100 an hour just for attorneys to talk to each other. But the trick is, how do we get that same information but without turning around and hiring an attorney? And with that, what you're going to do is you're going to write a letter. So you're going to write a letter to either the successor trustee or the executor, whoever's in charge of the administration that's going on, and you are going to demand all that information. Now, you're not just going to write a letter saying, hey, I'm so-and-so, I'm a beneficiary, therefore you need to give me these things. You don't want to send just a basic letter like that. It's too easy for somebody who may already be not sharing information as well as they should. A letter like that's too easy for them to ignore. So you want to put a little flair into there to make sure that they'll actually answer your message or turn around to their attorney and respond to it the way that they should. So firstly, we're going to talk about what if you're the beneficiary of a trust administration. So if you think you're a beneficiary or an interested person of a trust administration, by interested person I mean maybe the child of the person who's passed away, then you are entitled to at least some information, but we don't know exactly what you're entitled to, but we need to figure out what's there in the first place. So you're going to write a letter to the successor trustee of that trust and firstly demand that they give you notice as a beneficiary or interested party to the trust pursuant to their authority and duties under California Probate Code section 16061.7. I've talked about providing trustee notice under 16061.7 before in a video, so you can watch that one for more details there. But to give a little summary, a trustee of a trust who's going to be managing a trust after somebody's passing away does have a legal duty to provide a notice to the heirs and beneficiaries that there is this trust out there and that they are entitled to a copy of the trust. So with that duty is going to be your opening salvo to turn around and collect information to figure out where you can go from there. So you want that trustee to send you that notice letter in order to find out whether or not you're even entitled to any more information. However, that letter by itself still isn't going to tell you everything, because really what you need is the underlying documents. So in this case, the trust. The trust is going to say whether you get anything or not. Now, they are not required to give you a copy of the trust with that letter, but if you are a beneficiary or a natural heir, so again, a child of the decedent, then you are legally entitled to a copy of that trust, no matter what. Thus, when I'm representing the trustee, we always send a copy of the trust and the will with the notice letter to begin with, because we want to just cover those two bases right off the bat. Plus, what that does is for you as the beneficiary, the recipient of that letter, you have 120 days from the day you receive that letter in order to challenge the validity of the trust. If you fail to do so within that time period, then that's it. You can never bring up that argument ever again. Now, you can toll that time period by an additional 60 days by turning around and asking for a copy of the trust. So again, when I represent the trustee, we send out the letter with the copy of the trust, so they get 120 days, and that's it. You as the recipient, you're going to need to be aware. If you get that notice letter and there's no copies of documents, you have 120 days, but you can add an additional 60 more by asking for those documents. And you're always going to ask for a copy of those documents. But if they send you a copy of those documents with the notice letter, that's 120 days, and that's it. So you've got a little time period there to where you can challenge the validity of the trust. However, one thing to keep in mind, I'm only talking about challenging the validity of the trust, not the successor trustee's actions as trustee. Let me clarify. That challenge period is only for you to turn around and say that the trust is invalid because of XYZ reason. Somebody didn't know what they were doing when they set up the trust in the first place. They were incapacitated or somebody was twisting their arm. What that challenge period does not speak to is if the successor trustee were to start doing anything, let's say, shifty, or, well, let's just come out and say it. Let's say they were stealing money. You as a beneficiary always have authority to sue that trustee to find them personally liable if they were doing anything like stealing any of the money from the estate. But okay, you've got your notice letter, you've got your copy of the trust, and it says you're a beneficiary. What do you do from there? Do you turn around and run off to an attorney yet? Not quite. You don't have to yet. First, let's now figure out what you're even entitled to in the first place. And by that, I mean what assets are there inside that trust that might be coming to you. So as a beneficiary, you are entitled to information relevant to your interest. That's the magic phrase. And with that, you can now find out what assets are there in that trust. You can also ask for documentation, essentially proving what assets are there, like statements and ledgers as to the trust's activity and whatnot. And when you make that request, the successor trustee does have to respond to that reasonable request within a certain time period, in this case, 60 days. Now, going a little bit further, as a beneficiary or interested party in a trust, you are entitled to an accounting of the assets that are there within that trust. Now, the accounting formally is due at 3 different instances in time. The first of which is 1 year after the date the trust becomes irrevocable. So usually 1 year after date of death. The second is when the administration is all done. So last checks are cut, trust bank account is closed down, and we're all said and done with. The trustee has to provide an accounting to all the beneficiaries at that point in time. These 2 points in time can kind of overlap or be very close to each other. For instance, let's say it takes 13 months to close down a trust administration. Well, that's 2 cases where an accounting needs to be required. Once at the 12-month period, and then a month later when everything is closed down. Now, the third time period in which an accounting must be given to the beneficiaries is one that doesn't happen too often, but it's when there's a change of trustee. So let's say someone's acting as trustee, but let's say they have a debilitating illness and they need to step down before the administration is done. Then an accounting of everything they did during their tenure does need to be provided to the beneficiaries, and then the new trustee takes over from there. However, we can use that change in trustee trigger to turn around and say, I want an accounting of what assets there are in the trust at date of death. And the argument is that even though the trust became irrevocable as a result of somebody passing away, that trust became irrevocable and there was a change in trustee. So the initial person, maybe they were trustee of their own trust, very, very common, and then at their death, somebody new takes over as the successor trustee. That is a change in trustee, so I, as the beneficiary, would use that as the argument to turn around and say, I need to know what assets are in that trust as of date of death. Now, I'm not going to get a whole bunch of information and find out, the transaction history leading up to that point or anything too detailed, but at the very least, I can use that to get an answer as to what assets there are in the trust as of date of death, and that tells me what I need to look out for going further. Now, for all these requests that you make, or if they're all bundled into one letter, you need to put a time period on there. So, a time period in which they can respond. If not, then you're going to turn around and seek either legal counsel or just launch something more from there. Now, if things aren't too contentious, then I say, let's be pretty reasonable. Let's give somebody a good time period to be able to gather all this information, be able to respond to a reasonable request. So maybe a couple weeks, maybe a couple working weeks, just whatever you feel might be necessary or reasonable in the circumstances. We don't want to scare them too much to run off to an attorney right away if they don't have one, but we do want to know what's there. So we want to give them a timeline though. Now, how do we enforce that timeline? We need to know what day that letter was delivered. And this is where you would either send the letter by certified mail with the return receipt requested through USPS, or you can send it by FedEx or what have you, so that the person does have to sign for that letter so that we know what day it was delivered to that successor trustee. Now, from experience, when somebody sends that letter, even if they're not represented by counsel, the fact that there is some specificity in there to where they demand information, demand accountings, coupled with the fact that they put a time limit in there and that they sent it by a method that provides tracking, usually indicates to the recipient that this person's probably talked to somebody and they've probably been told, first, go ask for information, then come back to me, figure out what you have, and we'll go from there. So that usually tells them that they need to actually chop and get things done. Now on that note, I've talked a lot about just trust administrations, but it's going to be a very similar process with probates. For probates, you're going to send that information to the executor or administrator, whoever has been put in charge of the estate, and they have to provide that information to you. And if they're not providing that information, then you can always turn around and petition the court in order to compel them to provide that information in the first place. So with probates, because there is court oversight, we do have the court overseeing the process, so we don't have to worry about anything happening in the dark, so to speak. It's all going to show up in all the court filings anyway, but if you want information ahead of time, you are free to turn around and ask the executor or administrator to be able to provide that information to you. Now, something you're probably thinking is, why is an attorney telling me how to not hire attorneys? Well, firstly, the point of this channel is to, first and foremost, educate you on things, not necessarily to make you turn around and have to hire me to do anything, although that would be nice. However, in my opinion, making sure that things don't get out of hand by hiring attorneys to just blow up a perfectly reasonable situation, I think that's a pretty preferable outcome over having me come in to just bulldoze everything or have me come in and start fighting with another attorney. Now, I'll do that. I'll work with and advocate on your behalf. However, that's now just money that's coming out of your pocket in order to hire attorneys to do things that you're probably able to do all on your own. So all that is to say, if at the end of the day, you are a beneficiary of either a trust administration or probate, and you're maybe just getting the cold shoulder and you're feeling a little bit uneasy, my first recommendation as an attorney is for you to communicate directly to whoever is in charge, whether it be the successor trustee or the executor or administrator, to find out what information is there, what assets there are, and just what you're entitled to in the first place. Now, do so, be very cordial, send a letter, be nice and professional, but give them a timeline and send it by a method to where you know when it was delivered. And those are things that are usually good enough to be able to perk up somebody's ears and make sure that they respond to you within a reasonable time frame. However, if they don't respond, or they kind of only respond to maybe a little bit here, but maybe completely ignore the big thing over here, then it's probably time to turn around and hire an attorney and get a little bit more serious about it. You hire an attorney, it's probably going to slow down the process a little bit, but you're now auditing what's going on. And I've been on both sides of that, mainly on the side of the attorney representing the trustee or the executor, where we now got another attorney looking over our shoulder and auditing the whole process. In my opinion, it's probably the easier spot to be in because you're just looking to see what's going on, but still, it's just another person who's got their eyes as to what's going on, and we got to make sure we're crossing our I's and dotting our T's. If you're on that side and you want to make sure somebody's dotting their I's and crossing their T's, firstly, you do your little bit of work in the beginning, save yourself a little bit of money, but at the end of the day, then hire an attorney in order to take you to the next step and make sure that there's no funny business going on. But with that, have you been the beneficiary of either trust administration or probate where the person in charge isn't sharing any information with you? Let me know in the comments below. How did you solve it? Did you turn around and hire an attorney to do it for you, or did you just take the reins and do it yourself? I'm attorney Andrew Bethel, and I'll see you at our next meeting.